After the Norman conquest of England in 1066, royal judges began to travel throughout the land, holding court in each shire several times a year. When court was in session, the royal administrator or judge would summon a number of citizens who would, on their oath, tell of the crimes and serious breaches of the peace that had occurred since the judge's last visit. The royal judge would then decide what to do in each case, using local custom and rules of conduct as his guide. Courts were bound to follow the law established in previous cases unless a higher authority, such as the king or the pope, overruled the law. The law in contemporary society. In contemporary society, the law governs almost all phases of human enterprise, including commerce, family life, property transfer, and the regulation of interpersonal conflict. It contains elements that control personal relationships between individuals and public relationships between individuals and the government. The former is known as civil law, and the latter is called criminal law. The law can generally be divided into four broad categories. 1. Substantive criminal law. The branch of the law that defines crimes and their punishment is known as substantive criminal law, such as the Pakistan Penal Code, PPC 1860. It involves such issues as the mental and physical elements of crime, crime categories, and criminal defenses. 2. Procedural criminal law. Procedural criminal law deals with the basic rules of practice in the criminal justice system, such as those found in the Criminal Procedure Code, CRPC 1898. Some elements of the law of criminal procedure are the rules of evidence, the law of arrest, the law of search and seizure, questions of appeal, jury selection, and the right to counsel. 3. Civil law. The set of rules governing relations between private parties, including both individuals and organizations, such as business enterprises or corporations, is known as civil law. The civil law is used to resolve, control, and shape such personal interactions as contracts, wills and trusts, property ownership, and commerce. 4. Public or administrative law. The branch of law that deals with the government and its relationships with individuals or other governments is known as public law. It governs the administration and regulation of city, county, state, and federal government agencies. The four categories of the law can be interrelated. A crime victim may file a tort action against a criminal defendant and sue for damages in a civil court. Under tort law, a crime victim may sue even if the defendant is found not guilty because the evidentiary standard in a civil action is less than is needed for a criminal conviction, preponderance of the evidence versus beyond a reasonable doubt. In some instances, the government has the option to pursue a legal matter through the criminal process, file a tort action, or bring the matter before an administrative court. White-collar crimes often involve criminal, administrative, and civil penalties. Criminal laws are divided into felonies and misdemeanors. The distinction is based on seriousness. A felony is a serious offense. Crimes such as murder, rape, and burglary are felonies, punished with long prison sentences or even death. A misdemeanor is a minor or petty crime. Crimes such as unarmed assault and battery, petty larceny, and disturbing the peace are misdemeanors, punished with a fine or a short period of incarceration. Regardless of their classification, acts prohibited by the criminal law constitute behaviors considered unacceptable and impermissible by those in power. People who engage in these acts are eligible for severe sanctions. By outlawing these behaviors, the government expects to achieve a number of social goals.